Hi there, legal writers. Welcome to this Legal Grammar Redux video series with me, Jill Barton, from the University of Miami School of Law. In this video series, I am covering 12 grammar topics, which are covered in more depth in the handbook for the new legal writer in chapters 19 through 21. Those topics include 8 grammar basics and then 4 more advanced principles. And in this video, we are covering grammar basic number 7, apostrophes. In relation to apostrophes, we will discuss 4 rules, and we'll take those first 2 rules together. So for singular nouns, we are going to add an apostrophe plus an S. For plural nouns with an S already on the end, we are going to add just the apostrophe. And here we can see an example sentence from a Supreme Court opinion where we have both. We have a singular noun, petitioner. Here we're talking about one petitioner's child. And we are then talking about other petitioners, in that case, multiple petitioners. So we put the apostrophe at the end. If you're trying to figure out whether you need an apostrophe before the S or after the S, just take note of whether you have a singular noun or a plural noun. That'll put you on the right track. Apostrophe rule number 3 is that when you have singular nouns ending in S, that's a singular noun with an S, we want to follow either rule and be consistent. So this is an area where even the Supreme Court justices disagree. The traditional rule has always been that you should write, when you have a singular noun like Congress, to make the possessive, you would write Congress apostrophe S. And Justice Alito is demonstrating that here. But some people find this to be wordy or unnecessary, and they take off that extra S. We have a split of 4 or 5 justices doing it one way and 4 or 5 justices doing it the other way. So either way is correct. Just be consistent in which rule you are following. And so here we have Justice Alito following that more traditional rule, but he is quoting an older John Paul Stevens opinion where Justice Stevens just added that apostrophe. For the 4th rule, we'll talk about contractions, one of my favorite topics. So this is something that has changed dramatically just in the past 5 years. It used to be in Justice Scalia's era that the justices did not put contractions in their majority opinions, and only a few would drop them occasionally in their minority dissenting opinions. Justice Gorsuch has changed that. He uses contractions pretty regularly, and here's an example of him doing that here. He has a very conversational style, and he writes, "But what if you purchase a debt and then try to collect it for yourself? Does that make you a debt collector too?" That's the nub of the dispute now before us. This is in his very first published opinion as a Supreme Court justice, and he puts that contraction in that opening paragraph. So legal writing has changed a lot over the past few years. Even we've become more conversational, we've become more casual, and you can follow that too, but it's good to follow these traditional rules as well and know that many legal writers find that contractions are a little bit too informal for formal legal writing. So with that, I just want to remind you that everyone can be a great legal writer. Thanks for joining me, and I hope to see you next time.